Hi, everyone.
Hi.
Welcome back. This is a very difficult time for Houston. So I'm at once happy to see so many of you here bright and early in the morning, but also I see that some of you aren't here. I know I said in my email I'm not taking attendance. The dean is asking to take attendance. I'm not going to count it. What we want to do is see who's here and who's not. So if you're absent today, I will excuse it. It will not be against you. But the dean sent an email this morning saying he wants to know every student who's not present because they're going to contact them to see if they're okay, if they need assistance. And I don't say that lightly. Even if you're here and there's something the school can do to help you, tell me, tell the dean, tell someone else. If any of your classmates aren't here and you're aware of them, tell me, tell the dean. When you walk to see the dean in the lobby walking around handing little cookies and coffee, he's, you may not know much about him. He's a retired admiral in the Navy, and he knows a thing or two about water, and he knows something about keeping everyone on your ship safe and sound, and he views all of you the same way he would view as seamen and cadets and people underneath his command, so he's very much concerned about all of your safety. I got a lot of emails over this past week to make sure that we give you whatever you need to help get you back in order. So if you can check in, please do. If you know any of your classmates are not here, tell me. That way we can get them on the list and we can get them whatever help that they need. You weren't here last year when we had the Super Bowl. We thought that the Super Bowl would be a huge disruption for class because they had to, I didn't cancel classes, but some people canceled 1 or 2 classes. You've been out for about 12 days. This is longer than your spring break. So I fully understand that this is a disruptive experience for your studies, and I'm going to try and do whatever I can in my power to bring you back and energize you back to the study of property. In terms of the schedule, at least for this week and next, we're just going to push everything ahead. So we're going to do today class number 5. We'll do class number 6 on Thursday. At some point, probably next week, I'm going to take a poll and ask you what your preference is for makeup. I'll give you the options now so you can think about it. Okay? You don't have class before this, right?
Yes.
What time's your class before this? 9. So you have a class from 9 till 10:30, okay, and then what? You're from 10:40 till 12:10. What do you have after that? Okay. Some of you have class after that. Does anyone have class after 5? What time? 5:45. What time does what's your break before 5:45? 3:30. So you have a break from 3:30 to 5:45.
4. I got a class.
Okay, then it's gonna either be it'll either be at 7 or on a weekend. There's not ideal. I sometimes am able to do it. Do you have any break on Monday or Wednesday in the morning?
Yeah.
Some yes, some no. Okay, it's gonna be a night or a weekend, and I'll record it. Whenever I try and do this, I always get some yeses and some nos. And if there's a single no, the answer is no. So I'll probably have to do it on a weekend or at 7 o'clock at night. Not ideal. I will record it. Indeed, there'll be live streams. If you want to take it from home, you can. There will not be attendance taken. We'll work with you. Last year, I had a situation where the morning class started at 9 a.m. And I said, does anyone object to starting at 10? And there was one person in the class who had to make a legal writing class at 9. So he couldn't move it up. So basically, because of one person, we had to start at 9 instead of 10 for the entire semester. That person was not very popular. But my rule of thumb is if a single person has a class conflict, then we can't do it. So I'll schedule some evening and perhaps weekend classes. Again, it's not ideal, but we will make it up, and we'll cover everything. And again, all my classes are on YouTube or on live stream. And I see about 19 people are absent right now. I will give this list to the dean later. Again, I won't mark them absent, but the dean wants to know if people are not where they're supposed to be. Okay? All right, let me turn this off now. So let's try to get back into the flow of things with a question, which perhaps hits a little bit too close to home, but we actually talked about this. You remember way back when? Before we took a hurricane, right? It's awful, right? For 95% of Houston, that's how this is going to be for the kids not going to school till next week. They're probably all ecstatic. We talked about this, right? What happens if you're purchasing a home, the sale closes, and before you get a chance to move in, the storm hits and it washes the house away, right? On who does the burden fall? And we discussed that under the old common law rule, generally the burden falls on the buyer. Yeah, on the buyer. This was a doctrine of merger, which we mentioned in the reading. The idea that once all the paperwork is finalized and everything's put into writing, the buyer is the effective owner of the property, even if he didn't take ownership of it. But under the more modern doctrine, courts use various doctrines like fairness, estoppel, to say that the seller remains in possession and the seller may have the burden. So that was what we had last week, right? Remember the haunted house, right? Remember these sort of defects? Today, we have a slightly different situation where it's not just a dispute between the buyer and the seller. There's a dispute usually with a third party. And that's what gives rise to the question I put on the board. So I'm going to start a quiz session if you take out your fancy phones. And I put a question on the board. So A sells a house to B. Okay. After the sale, B discovers that there are latent defects in the roof. Okay, who should B sue? Okay, think about a minute or so, see what you think. A sells a house to a B. After the sale closes, there's a defect discovered in the roof. Who should B sue? I think that's all about the attendance we have today, so I'll stop it here. Okay. I have no idea where I finished last week. So, you remember? Are you next? Wow. Give this guy a medal, right? Give this guy a pat on the back. Good job. Walker, I am so proud of you. I have no idea where the hell we were, but you obviously were thinking all week, oh crap, I'm next, right? Yeah. Dreading. All right, so an easy question. What did you put, A or B?
I put B.
Okay, you said the roofer. Why did you say the roofer?
Because under the implied warranty of working light quality, he's the one responsible. It was a latent defect, and it was discovered after the sale closed.
Good.
So he should be ultimately responsible for that.
Now, you're the buyer, right? Let's pretend you're the buyer.
Okay.
Do you even know who the roofer is?
I mean,
How would you find out who the roofer? I mean, maybe he left his card in the roof, right? But how would you probably find out who the roofer even is?
You would have to contact the owner.
Contact who specifically? In this problem?
The owner responsible.
Who was?
The previous.
Yeah.
Okay.
The guy you bought it from, right?
Right.
So you contact the guy you bought it from, and you say, "Hey, you sold me this house. The roof has these leaks, right?" And then what do you think the seller is going to tell you?
Not my problem.
Not my problem, right? So here we have a situation where the buyer is like, "Uh-oh, let me go call the guy I bought it from, see what the deal is." He calls the seller, and the seller says, "Dude, not my problem. Here, go contact the roofer," right? What'd you put?
I put the roofer as well.
Okay. All right, so now you said, pretend you're the roofer, right?
Right.
And this guy shows up in your store. He's like, "Yeah, you built this roof for, the seller 25 years ago. Your father, right? Your father's done business. But your father built this roof 25 years ago. I want you to fix it." You're the roofer. What do you say to him?
I don't know who you are.
Yes, exactly. Oh, what a perfect answer. A week off, not even rusty, right? I don't even know who you are. Why is that what the roofer's going to say?
Because he built the roof for the previous owner.
what do we call that in legal terms? I don't know who you are. How do we describe that in legal? Yeah, exactly. So you guys are right back into swing things. Very good. I thought you'd be rusty, but I'm pleasantly surprised. There's no privity. There is no privity, right? The roofer did a business transaction with the seller 25 years ago, whatever it is. That's where the relationship is. So Yusuf, finish it up. If you're the roofer, what do you tell the buyer? What's your response to them?
That they have to pay for the
Well, not just that pay. Who are they supposed to sue?
seller.
Exactly. Okay. So everyone sees what's going on here, right? With privity. Under the common law rule, the only person you could sue were those you were in privity with. Does that sound familiar? Torts? Cars, remember the car manufacturer, the car dealer thing? Remember, that sound familiar? I can't remember the name of the case. You'd learned it, right? Where there was a defect in an automobile, and the guy tried suing the car dealer or the auto manufacturer. They said, well, even though you bought it from this guy, you can still sue the manufacturer. Remember that case? Anyway, it's the same concept now with property. Even though your relationship was with the buyer, courts say that now you can sue the seller, but not in all circumstances. Because you can imagine there's something problematic, right? Let's say, again, the guy built the roof 30 years ago, and through normal wear and tear, roofs come apart, right? They start leaking, there's a big storm, whatever. So there are certain limitations placed on when courts will waive the requirement of privity, right? There's certain instances where courts will say, okay, this is too much, you need privity. But in other cases where the courts find that there's a good equitable reason, they will relax the concept of privity. So I think, okay, good, yeah, I think most of you put B. But I'll tell you, the people put A, you're not wrong. Under the common law, A is correct, right? Under the modern trend, I think B is correct. Because it represents different ways of recognizing privity. Yes, Valerie?
So the way I read it, I also thought it could be either or, but I was thinking more, since it's a latent defect, if the seller knew about it.
Oh, good. So if you were to sue the seller, though, what would you sue on what basis would you sue?
Malfeasance.
Well, is it malfeasance or tell us, what's the difference between malfeasance and nonfeasance here? These words sound a lot like, let me type them out. You have malfeasance and nonfeasance. Valerie, what's the difference, please?
Malfeasance is when you lie, and nonfeasance is when you don't.
When you stay silent, you don't say a damn word, right? You play dumb, right? Oh. So if he says, what's wrong with the roof? And you say, well, the roof's fine. He just lied. If the other guy doesn't ask you about the roof and you stay quiet, nonfeasance, right? So if the person actually lied about the roof, and you have a case of malfeasance, you can then sue directly the seller. But would you want to sue the seller, Valerie? Would that make even sense? Would that even make sense to sue the seller?
I guess it depends on what you want from it.
Uh-huh.
Like if you want to rescind the contract and give them back the profit.
Yeah, okay, so that's your answer, right? If you want to fix the damn roof, you're going to sue the roofer, right? If you want to try and get out of the contract, you sue
The seller.
the seller. Right, everyone get this question. Let me try a different variant of it, right? Okay. Let me just make the facts like this. X is the original owner and contracts with the roofer to repair the roof, okay? X sells to A sells to B. So I just changed the question, right? I changed it up. I said, X is the original owner, and he contracts with the roofer to repair the roof. After that, X sells to A, and then there's another transaction, A sells to B. And then after the sale closes, B discovers a defect. Okay? Same choices. Now we have a C, right? Try this one. See what you guys do with this one. See if it changes your answers. Does this change your answer, A, B, or C? seconds or so. Okay, let's see what we got. Virginia, did this change your answer at all? The addition of X?
I didn't change my answer, I kept it to B.
Okay. Why don't you think that the addition of X makes any difference?
Because it's, I thought because it's still a latent defect that it would still fall under the roofer, because you want to fix the roof.
Yeah, but there's another layer of removal, right?
Right.
Because the only person in privity with the roofer is X.
Okay. Well, I was
B is
between
not
the
even in
roofer and
privity
X.
with him.
Right.
A is not in privity with him. Does this matter?
I mean, I was in between either the roofer or X. but I,
It's a little. Did anyone change your answer with this wrinkle? Is that Anna? Yeah, the back. What'd you put? Okay, why'd you think X?
I thought that I was too far away.
Yeah. Well, give me more. Why is it too far away? Explain that a little bit more, please.
It's just kind of, I just feel like you could sue either A or X, and they're gonna bring in whoever they think is responsible anyway.
Oh, bring in. What's that called? Remember the CIFRA word? What's the CIFRA word? Implead. Yeah. Jill, you want to add something, please?
I think it just kind of depends on the circumstances. With
Well, what a lawsuit answer, man. God, don't ever write that in the exam. You're not getting any credit.
well, I'm saying like if
Yeah.
it was,
Yeah.
if the contract was formed like she was saying like years ago,
Ah.
it's not a reasonable time. to
Reasonable.
say that
Oh, okay. Simone, what you put? What, do you think this makes a difference with the addition of X to this question?
Well, no, I didn't change my answer. I was just kind of going with what Jillian said. Like, it just depends on the time. Like, depending on, like, whenever you have subsequent buyers, it does have to be a reasonable time.
Why? Why does the addition? You're exactly right. Why does the addition of subsequent buyers change the analysis? You're exactly right. Why don't you tell me why?
It changes because, like, one, because of privity. Like, you have to have, you don't have to, the common law rule said that you have to have privity in order to sue.
Uh-huh.
But when you have subsequent buyers, they shouldn't, sometimes they're not aware of things.
Like what? Like what? You actually anticipate my next question. What are they not aware of?
Yeah.
I'm sorry, one at a time, please.
Oh.
Raise your hand. Okay, but what else? Raise your hand, please.
They're not
Okay, let me ask, Lauren, you're next. Let me ask you this question. What happens, let's say that the roofer and X are friends, right? Let's say they're good buddies. And the roofer says to X, hey, it's going to be $10,000 to fix your roof. And X like, look, I'm short on cash. Can you use like, shoddy materials? I'm only going to be living here for a few more months, I'm about to sell it. Just do a crappy job. I'll pay you half. And X like, all right, fine, but I'm not going to give you any warranty. No written warranty. Okay, fine, I'm not going to sue you. What happens then?
At that point, then X is responsible because X knew of the circumstances, the leaky roof, and
But let's say you stay quiet. Let's say we have non-feasance. Let's just assume there's no malfeasance here, right? Let's say there's non-feasance. He said, one at a time, please. He said, I want you to build this with cheap materials. You don't have to give me a written warranty. Does that matter?
yes,
Why?
because it's still an implied one.
Ah, exactly. So what often happens, right, is we have a situation where the original owner, X, has some sort of private circumstances with the roofer. And it's like, look, I'm going to give you half what you asked for, do a crappy job, I don't care because I'm moving out. The guy's flipping the house, right? It happens. People want to sell the house quickly for profit, and who knows if the roof breaks or fire or whatever. He says, okay, fine, but I won't give you a written warranty. But what the roofer needs to know is there's implied. And what does implied mean, Lauren?
Implied means that even though you don't have a written warranty, there's still a certain quality that you must go through based
And who
on
enforces that implied warranty?
it's by your standard of your job.
But who enforces that if you don't live up to it? Courts, thank you, exactly, yes, thank you. So the courts then imply the warranty. So here we have the situation, right, where I sense what you're saying is like, yeah, there's more attenuation, maybe things change, maybe X had some sort of relationship. So in that case, maybe it's less fair to hold the roofer accountable, right? As you move further and further away from the roof job, it becomes less and less fair to hold the roofer accountable. So I'll give you a second. Let me just see what the results popped up here. See if it changed a little bit. Okay. I think you might be right. I don't know. B is certainly correct, but I think it's a little bit closer to X in this case because I think there's the original. But anyway,
I wanted to put D and C on.
D. Oh, don't mess with me, please.
Because it's too many facts that's missing.
And this is why I don't give you multiple choice questions in the exam. I hate multiple choice questions. In fact, I like true and false much better because you gotta pick, right? Is that Tyler?
Yes. Isn't the issue here not how far it's removed and whatnot? Isn't the issue the statute of limitations based on the years since the job has been
Well,
completed?
what's the statute of limitations for latent defect?
6 years
Or 6 years from when?
from when the job was completed.
Or so statute of limitations can be told, right? Basically, you stop the clock. A number of jurisdictions effectively say with a latent defect, the clock starts ticking when you notice it, or you should have noticed it. The entire point of a latent defect is that it's not noticeable, right? So imagine, I'll use an easy example. You have some sort of crack in your roof, and it only starts leaking when you have a tropical storm, Category 4, that hits your backyard, right? Unless you have a storm of that nature, I mean, there are a lot of people, I'm sure, in Houston who had no idea they had leaky roofs until this past week. I had some water damage in the wall. I didn't know my wall had leaking, but apparently it did. So the statute starts ticking when you discover what you should have discovered. If it's a regular defect, something that you can see, when you walk in the house with an inspector, that's fine. These are latent defects. Or to think of I'll get to in a second. Think of the ghosts, right? How do you know when you can discover your house is haunted? Maybe the ghosts are out for the day, haunting somewhere else. Justin.
I want to go back to, you said if like X and the roofer had kind of like a sham deal where they're
Right.
just saying, would you not hold, and you mentioned that X may be the right answer there, would you not hold the contractor, someone who's skilled there, like a higher, to a higher standard? Because they know that obviously both people know they shouldn't be doing this, but he's a contractor.
And that's why the implied warranties are dangerous. Because even if you say, I want you to do this on the cheap, no, don't give me a written warranty, it doesn't matter. So that's why the contractor probably is also on the hook here. But the question is, can you go after the contractor directly? Or do you sue X, who impledes the roofer? So I think the best answer, under the common law at least, is you sue X, who then impledes the roofer. Or perhaps X's successor in interest, because he died, his son or daughter or whatever. Yeah.
Would it not be in your best interest just to go to the roofer? It's more likely
But
the
under the
roofer has
common
more
law, you
money.
couldn't. That's what I'm trying to get to.
Okay.
If the attenuation is too big, you can't sue the roofer directly. You'd have to sue X, who then impledes the roofer. And that's a three-way litigation, which I guess you didn't sit pro. Use it.
Aren't they worried about opening the roofer up to unlimited liability?
Yes, why? Exactly right. Explain.
I mean, like your example, you said they come back 25 years and the roofer's son is taking over the business.
Yeah.
He has no idea.
That's why privity existed. So if there's too much, what's called attenuation, right? Too much of a gap, they say, okay, you know what? Actually, do you know how this would have to go? A and X aren't in privity, are they? I'm sorry, B and X are not in privity.
No.
So you want to be precise what's going to have to happen? B sues A sues X sues the roofer. So that's why the courts are okay with just loosening the privity requirement, because it saves like 3 lawsuits and turns into 1. Right? B sues A sues X sues the roofer, or cut to the chase, B sues the roofer. Which is what everyone wants anyway, right? That's what they want to get. Unless, like Valerie said, which is correct, they're trying to get out of the deal. If they're trying to get out of the deal, they have to sue the seller. Mark.
But going off of that, wouldn't you, even if I could sue the roofer, if it has been 25 years, I also have to prove it. So then you get into a situation where...
Right. And the mere fact that you can sue the roofer doesn't mean you win, right? The roofer could raise a defense and say, look, a roof wall is only good for 15, 20 years. Or maybe this has been in a very high rain area and there's unusual stress. Even like my parents, they had a roof installed maybe 20 years ago, and the person who did it didn't put proper ventilation, so it starts to buckle out with the heat, right? And they say, well, you never have fans up there, right? That's what people say. So, there are lots of defenses of why things break after some years. But yeah, the time, I think, is a big factor towards reasonableness. So everyone else get with this question? Okay. Good. This was my plan to warm you back up before we get into the cases. All right. Justin, I think you're next. Give me the facts, please, in which Lemke versus Deginas, which is more or less what my hypothetical play was based off of.
Yeah, you had the owners of the house who hired Deginas, who's a builder to build a garage. They ended up selling the house about a year later to the Lemkes. And then shortly after that, the Lemkes noticed that the garage had structural defects and whatnot. They contacted Deginas, the contractor, who said he would fix them, but did not, and they sued them, the contractor specifically.
Okay, so, I mean, this is basically the question I have here, right? So you have, the contractor, which is Deginas, right? I'm going to spell it wrong. I always spell this wrong. You have Lemke, who is the buyer. Or did I get reversed? Yeah. Oh no, Lemke was the seller, right? Okay, and then you have the buyer.
No.
They reverse it.
The buyer.
I'm sorry. So you have Lemke was the buyer, right? So then, Elena, who's missing in this transaction, right? So you have the contractor, you have the buyer.
The previous owner.
Yeah, exactly. I'm sorry, I got the names reversed in my head. So you have the previous owner, right? We'll just call him seller, make it easy. So, Elena, under the common law, right, what would Lemke have had to do here to make this lawsuit work?
He would have had to sue the seller.
Who would then?
Sue the contractor.
Yes, right? So under the common law rule, the way to go is Lemke would sue the seller, and the seller would then implead or bring into the lawsuit the contractor. That way, privity is all lined up. Everyone has privity correctly. Very good. Okay, Hanan? Hanan, what happened here instead?
The court said that.
No, what litigation? Who sued whom?
Oh, Lemke sued the contractor.
Directly, right? Okay, so under the common law, was that sort of lawsuit permissible? How come?
Because there was no privity between the buyer and the contractor.
Yes, exactly right. Okay, so under the common law rule, the buyer, Lemke, was not in privity with Deginas, the contractor. Right? So this is the exact question I asked Yusuf like 20 minutes ago. Lemke shows up to Deginas like, hey, you guys, fix my stuff. He's like, who the hell are you, right? I don't know who you are. I'm not in a relationship with you. Go take it out with the guy who sold it to you, and maybe he can sue me. Okay? So at the time in New Hampshire, that was the rule, right? The common law rule in New Hampshire was, unless it's privity, you can't be sued. So, Lindsay, let me ask you this question. You're the lawyer for the contractor, the Deginas, right? And he goes to you, hey, Lindsay, look, this guy Lemke shows up, said I did some work for his seller, he wants me to fix it. What's your advice to the contractor before this decision was released?
He can't sue you.
Yeah, so what's your advice to your client? Do you have to help the guy?
No.
Should you help the guy? Oh, God, you have a soul. Good. Yes, I think that's good advice, right? Lawyers should have souls. You can say, look, you should help the guy. If you did a crappy job, you should probably fix it. It'll be good for your reputation, right? But as a legal matter, you're on solid ground. He can't sue you because you're not in privity. And you hold up this Ellis, right? This Ellis decision. He says, look, we got a decision in New Hampshire Supreme Court, Ellis, saying that unless you're in privity, you can't be sued by a subsequent purchaser, right? You can be sued by the seller, but the subsequent purchaser cannot sue you. But alas, as you're sensing in this class, any common law rule that seems certain will not last very long. All the common law rules in property 2 fall apart like a house of cards. Megan, how does this house of cards topple?
The privity one?
Yeah. How does Ellis? What's the fate of Ellis?
Oh, they abandoned it.
Okay, why did they abandon it?
They basically said it wasn't worth it.
Because it wasn't what?
Fair.
Fair. Oh, my least favorite four-letter F word, right? Why? I mean that sincerely. I hate that word. There's no actual. After the semester, this word of no meaning to you. It's whatever. Why does the court say this common law rule is unfair?
I mean, they give kind of 5 reasons.
5 reasons. Okay, give me one or two.
Okay, so they said, one of them says the common experience teaches the latent defects in the house will not manifest itself for a considerable period of time. So basically.
What does that mean? Your own words, please.
Yeah. So basically that no one really knows about it.
Right.
So
The buyer doesn't know. The seller doesn't know.
yeah. So
Okay.
so whose fault would it be if it's not?
But then
the
why
person's fault?
can't Lemke just sue the seller and then add some more litigation? I mean, it makes litigation a little bit more complicated, but it's fair. I think it's fair.
Yeah.
So you don't have the contractor being sued by foreign people he doesn't even know. Anthony, what do you think? Why is that unfair? I mean, why can't the contractor be certain that he can only be sued by people he works with? Why is that unfair? What does the court say?
Well, the contractor built the house.
Right.
Built the garage, so he's the one that has contact with the defect, where the seller.
Well, with the defect and with whom? He didn't make a contract with the defect,
No,
right?
but the original owner, if it's a latent defect, I think the first reason is that if the seller is never aware of a latent defect and sells the home, he shouldn't be drug into court to implead someone else.
But he sold the defective house.
It was latent, he didn't know it was defective.
Oh, what do you think, Robert?
Not fair, please.
Okay, that's fine. William, what do you think?
Can you repeat the question?
Why is the common law rule unfair? Why shouldn't it be the rule that you only get sued by people you're in contract privy with? Why do we need to change this rule?
Well, I think, so, it would seem very, very unfair, I think, to this court that, like, somebody who doesn't know anything about houses would not be allowed to sue somebody who would know about houses, and that a contractor would be in a position to know whether there's a latent defect.
So you think the contractor is in a better place to deal with the situation, right?
Seems so.
Christine, what do you think?
I think you should protect innocent buyers and
Protect innocent. Why are the buyers so innocent? Why are we so obsessed with the buyers? Why don't we care about the sellers being ambushed by some random guy showing up their shop, right? Why are we so fixated on the buyers?
because latent defects take time to show up, and so the buyer's not gonna find out about it until after he buys it.
Okay, good. I think we're more or less hovering in the right answer. The court gives what? 9, 10, 8? I always lose count. They give 8 explanations. Most of them are the same thing. It's unfair to the buyer. They just say it in different ways. So, latent defects don't appear for a long time, right? Number 1. Number 2, they say that society is rapidly changing. Houses are sold and resold quickly. This was the flipping example I gave you earlier, right? If, X contracted with the contractor to put up a shoddy roof, knowing he's just going to sell it and flip out the house next month, he's not going to be concerned about getting it right. The third rationale the court gives is that a subsequent buyer has little opportunity to inspect the construction, right? Think about it. When the roof is being done for X, in our example over there, the subsequent buyer's not there to inspect it, right? The person who is there to inspect it is X, which I think is another reason why X should be involved in litigation, but the court has abandoned that role. Number 4, the court says that the builder already owes a duty. There's no problem with extending it. So if the seller has a duty to the original buyer, what's the big deal with extending that duty to the subsequent purchaser? 5, I think is the same as 2. Privity might encourage sham sales, insulate the buyer from liability. So you can imagine, I can't imagine this happening, I suppose it could. Someone contracts to have a house bought on the cheap and make everything, really cheap. He sells it to a friend who immediately sells it back to him. And that straw purchase is done to cut off any liability for the buyer. So here, even if you have this middle purchase that's a sham, you still have liability attaching to the contractor. Number 6, I think it's the same thing over and over again. The builder is in a better position to guard against financial risk. He is the least cost avoider. Number 7, I think it's the same thing. It's not logical to limit to the first purchase. And then number 8, they talk about the UCC. Note that the UCC does not concern real property. It concerns goods and services. So it's something of a non sequitur, but as you can tell from these decisions, the court has incorporated tort and contract doctrine to property. So these are lots of good reasons to abandon the common law rule. Everyone get why they abandoned the common law rule. Okay, then in the third part of the opinion, they put some limitations in there, right? This row's empty. David, what are some of the limitations the court puts on this new common law doctrine? That's okay. Mark?
Yeah, I put like the courts are the courts that allow to do so because properties. I'm sorry, I might be a little. Oh, limitations. I'm sorry. Well, they talked about reasonable time limitations.
Okay, good. And we talked about this earlier, right?
Yes.
What's the limitation by time? Why is it important?
Well, I believe it was said 6 years, but I don't remember reading that in the case. They were basically saying that although the reasonable time doesn't necessarily exist, is what I remember reading, they said that you can basically sue without privity, you just need to be able to prove it. So if you can't prove it, and it's been like 25 years, there's no way that you can
you sue over any sort of defect?
No.
What kind of defects can you sue over?
They mentioned limited liability, or limited to latent defects, which
Good.
become manifested.
Good. Okay. So you're starting to read the test. Let me read out loud.
Yeah.
The court limits this holding to latent defects which become manifest after the subsequent owner's purchase and which were not discoverable had a reasonable inspection of the structure been made prior to the purchase. Let me say that again. The court limits its holding to latent defects which become manifest after the subsequent owner's purchase and which were not discoverable had a reasonable inspection of the structure been made prior to the purchase. What does that mean, manifest? That's when you discover it, right? So after you discover it, there's no 6-year clock. It's a reasonable time frame. How long is reasonable? Well, we base it on the reasonableness standard. How long is that? I couldn't tell you. Also, the plaintiff has the burden of showing that there was poor workmanship. So the mere fact that you can sue the roofer for these latent defects doesn't mean you win. And in fact, the longer you wait, the more likely it is that the damage can be attributed to normal wear and tear, right? Over years, that a roof becomes leaky, right? Things break over time. Heat, rain, whatever it happens to be. So here the court overrules Ellis, this common law precedent, which had been reaffirmed, I think, a couple years earlier. This was a pretty quick reversal.
That's the dissenting opinion.
Okay, yeah, finish it up. So what does, by the way, this is Justice Souter, who would go on to serve in the U.S. Supreme Court. We don't talk much about the Supreme Court in this class. We will later in the semester. But Justice Souter was appointed by President George H.W. Bush to the First Circuit Court of Appeals in Boston. And he was viewed as a stealth conservative. This stealth conservative, because he hadn't had much of a record. And then after a couple months of service in the First Circuit, President Bush, on the advice of his advisor, John Sununu, put David Hackett Souter on the U.S. Supreme Court as the replacement for William Brennan, the liberal lion himself. Souter turned out to be a considerable liberal, didn't side much with the conservatives of the court, and this is one of George Bush's perhaps biggest mistakes in office. But this was probably one of the decisions that was cited, saying, look, he's conservative, he likes the common law rule, right? He favors rules of privity, so of course he'll be good on all these other hot-button constitutional issues. Not so fast. Mark, what does Souter say here?
He says that it's kind of redundant to basically take away something that was affirmed just 2 years ago.
Yeah. 2 years, right? I mean, the common law is supposed to work itself pure over a long period of time, not reversing itself suddenly in 2 years. Because again, I think I asked Lindsay this question a couple minutes ago. If you were a lawyer and you told the contractor, you have no obligation to help, and now you have this decision, your client's screwed, right? Because he has to pay for it, and he has to pay for legal fees. You're probably not getting paid. And he may sue you for legal malpractice. You don't think about this, but just pause for a minute. You give your client advice based on what the law is today. A couple months later, the Supreme Court of New Hampshire reverses that law and says, no, the law's something different. How do you explain it to your client? Sorry, they did something unexpected, they were wrong. Whenever you have a decision like this where a common law doctrine is reversed, think about your position as an attorney and what sort of advice you would give. Okay. Anything else on the first case? Okay, good. So I think the first case, the first case represents what is certainly the modern trend. And I think most jurisdictions have more or less dispensed with the privity requirement. Okay. In the notes afterwards, a 6-year statute of limitations is mentioned in the ULTA, the Uniform Land Transaction Act. I probably will not mention that at any point for the rest of the semester because most states haven't adopted it. It's like a restatement of property law, but it hasn't been widely adopted, so it doesn't give much much weight. All right. Any questions on the Lemke case? Anything on Lemke? Okay, let's move on to the next case, Jones against Lee. And this is a case that should be familiar to you from contracts because it discusses what are the remedies available in the event of a breach. And generally speaking, there are 3 sorts of remedies available for breach. You can seek damages. You can try to get your deposit back if you're the buyer, or if you're the seller, you can keep the deposit, right? That's called restitution of the deposit for the buyer. Then for the seller, it's called retention of the deposit. So make sure you understand restitution for the buyer, retention for the seller. And the third option is one you're familiar with, specific performance. Amy, what's specific performance?
You want the person to act on, so if you had a contract to sell the house, you want them to sell the house.
Very good. Do you remember in contracts what the general rule is for specific performance? Was that a preferred remedy? Did courts in contracts like issuing specific performance?
No, because each piece of land is unique.
Not. You answer my next question. Not in property. In contracts, is specific performance preferred when you're selling widgets, for example?
Widgets, yes.
Why would specific performance be preferred when you're selling widgets?
Because if you make widgets,
But specific widgets or widgets in general?
In general.
That's right. So this is the rule from contracts, right? Let's say you manufacture widgets, and someone has a contract for 100 widgets, and you miss your contract. Do you have to deliver those specific 100 widgets, or maybe 100 new widgets that are created and identical?
If they're identical.
Yeah. So when you're making widgets, and they're identical, 100 here, 100 there, makes no difference. They're all fungible. But property is different. Nicole, you got your name tag?
I'm sorry.
Green, next class. Nicole, why is property different than selling widgets?
Well, I remember in contracts when they didn't want to make specific performance like a preferred remedy because in the case with the opera singer, they don't typically want to make people do stuff against their will.
Yeah. Why not?
Because people are going to perform, not up to
Yeah.
par, and it's just,
Good. But then why is property different?
Property is different, I would probably say, because typically there's contracts involved, and it's a piece of property, it's not forcing someone.
What about property is different than an opera singer? Or widget, whatever happens to be.
With property, you can give, an equal amount. If you can't award actual property that's in dispute, you can give.
Is
money
one piece of
damages.
property the same as another piece of property? What if they want black acre? They not take white acre instead.
No, all real estate is unique.
Yes, exactly. All real estate's unique, right? And that's a basic building block of property law. Each piece of property is distinct. So as a result, specific performance is available in property disputes. If you remember the case we did before our break, you had it was a Massachusetts case, right, where someone took a deposit check and she didn't cash it, and then she sold to someone else for more money, right? And they said, well, I want specific performance. And the court said, yeah, you can have specific performance if you actually need the house, because we thought at that point the person moved somewhere else. But if a person is waiting to move into a house and they're staying in a hotel in the meantime, right? Courts will actually award specific performance, even if someone's living there, which is a weird remedy altogether, because each piece of real estate is unique, unlike a widget, which we're all the same. Okay. Is that Casey? Oh, use your old name tag, not your new name tag. It's hard for me to say. Yeah, that's fine. It's hard for me to read the smaller letters. All right, give me the facts, please, in Jones v. Lee.
So there's a seller and a buyer, and basically the buyer backs out of the contract, so then the sellers resell for a lower price, and they want the difference.
Oh, very good, very condensed. Now let's walk through that for a bit. Why did the sellers back out of the deal? Right? Why did the sellers not go through with it?
They couldn't come up with the rest of the finances.
Was that the truth?
Or enough they were telling people.
Ah, good. Antonella, why is there reason to think that maybe they had the funds to do this and they were maybe trying to play fast and loose here?
Because they looked at their bank account
Yeah. Yeah.
and it was like sufficient.
Yeah. So here we have a situation where, right, the buyers agreed to buy the house for $610,000. They put down in earnest money a down payment $6,000, which is a very small amount, right? That's like 1%. I'm surprised they got away with that, such a small down payment. A couple weeks later, the buyers say, "Hey, we can't, complete the deal," and they say, "Look, you keep your $6,000." Okay. The sellers then go back in the market and resell it for $540,000, which is $70,000 less. Okay. So there's no dispute, right? Everyone agrees that the seller can keep the $6,000 deposit, right? Everyone agrees with that much, right? There's no dispute. You breach, you don't give any good cause, you forfeit the deposit. But the question is, can the damages go above that, right? Can the sellers recover the 70 grand, or actually $66,000? I'll make it 70 to make it easy. Can they recover the $70,000? That is a difference in the purchase price from the first transaction to the difference in the purchase price for the second transaction. Okay, is that Stormy? So what does the court do here? Can the sellers recover from the breaching buyers the difference in the purchase price?
No.
Well, yeah, you're not wrong, right? Walk me through it, because the opinion is a little bit tricky.
So it says where the market value at the time of the breach is the same as the contract price. The sellers are generally limited to the recovery of only nominal damages.
Ah, okay. What do you mean the prices are the same? What do you mean? How can the prices be the same?
The contract price was the same, I guess, like the market value whenever they breached.
What is the market value of a house, Stormy? Let me ask you that question. How do you calculate the market value of a house?
Well, the court said that you can base it off of...
Base it on. But is it necessarily the sales price?
No.
Good. Exactly. So here's how this works, right? You might think at first instinct, well, if we want to calculate the market price, we simply look to the sales price. Not necessarily. What happens if the seller was a very bad negotiator, right? Terrible negotiator. And she walked in and she said, my house is worth $610,000. And the buyer goes, yeah, I'll give you $540. Deal, right? And they just walked all over it. Or let me give you a different example. She said, screw it. I don't care how much he gives me because I'm going to sue this guy for the difference. Oh, right? He says, look, you give me 540, let's get this off my plate. I'm going to go back and sue the original guy for whatever the difference is. I'll get my 610 no matter what, and some attorney's fees added. So there's an honest question, right? How do you calculate the value of a home? Now, I think Stormy said it correctly. The sales price is evidence of the market value. It's evidence of, but it's not 100%. And the error of the trial court was not making a finding as to the sales price. I'm sorry, as to the market price, right? The trial court didn't make any findings about what the market price was. This is actually a fairly common error that trial courts make. If the trial court had simply said one sentence, I determined that the market price is based on the sales price and other market conditions, this would have been affirmance. But the failure to say that is mistaken. This is why if you are all lawyers, you make sure that the court's finding of facts, right, are complete. Because this could have been an easy affirmance for the buyers if they didn't do that. Okay? It's entirely possible, as Stormy said, that they go back to the trial court and they find that the market value was in fact 610 and the seller was a bad negotiator and he sold it under the market price. And he sold it under the market price. Stormy, what damages did you get?
I'm sorry, if he sold it under the...
Yeah, basically, even though the market price was 610, he sold it for less. What are his damages? I think you said it a minute ago. N, because of an N.
Oh, nominal.
Nominal. What are nominal fees?
Damages that are actually...
Yeah, so that might be like the listing fees, right? The broker fees, things of that nature. But not the difference in price. So more likely than not, after this is remanded to determine the correct market value, I think the seller probably wins, but it's not an open and shut case. I want to skip the discussion on special damages because it's far beyond our study. If you want to talk about Hadley versus Baxendale later, we can do that. I don't. Tyler, let's talk about the punitive damage, though. When are punitive damages, Tyler, usually even available? We don't talk about that in property much.
Punitive damages are not, it's a tort law.
Yeah.
And it's not.
Are they available in contract?
No, you can't.
Not.
Yeah. Equity based?
Yeah. Yeah, I mean, punitive damages, you call them punies for short. It's an award of damages to persuade sellers, this is really wrong, right? You had very poor judgment. We want to punish you. Tyler, in this case, why do they think that punies are appropriate?
I guess because essentially they were lying in order to, they were being not good purchasers, they were trying to bully around the seller to
Yeah, there's some allegations that they called the buyer and they tried to frighten them on the phone or something, and they lied about their financial circumstances. They had $600,000 in their checking account. It's a big checking account. This was some years ago too. They said that the failure to consummate the deal was, quote, wanton, utterly reckless, utter disregard of contractual obligations. That's pretty heavy, right? That's pretty damning. So there may have been stuff in the record that wasn't reproduced. It didn't sound too bad to me. I don't know. Maybe I'm a jerk. I don't know. But this seemed to be below the threshold of punitive damages, but the court upheld the award. But this is rare. Generally in property, we don't have the notion of punitive damages. It's not. It doesn't exist. A couple of cases this semester you'll see them, but those are outliers for certain. All right. So the takeaway from that second case is that when you're calculating the measure of damages, you have to ascertain the market price, and the market price may be based on the sales price, but it doesn't necessarily have to be the same. Usually it is, but it doesn't have to be. I had one case when I was clerking, which was a slightly different scenario, where you had, this was during the foreclosure crisis, it was in Detroit, where you had like an entire block of houses that were all foreclosed, and due to the financial situation, nothing was being sold, right? None of the houses were sold, they were all foreclosed. How do you calculate the value of a market price of a house that no one wants to buy, right? Is the market price 0? it was a very difficult case. The judge had to bring like economists and people to make projections what a house would have sold in different economic conditions, but basically you had an entire block, if I recall, of houses that no one wanted. So the effective market price was 0. And that's what the bank argued. Or I'm sorry, that's what the owners argued. They're trying to get out of the mortgage. And they look, the house is worthless. You know, the family. I don't think that worked. I think at that point you assess the value of the land itself and not even the house. Okay, anything else in the second case? All right, let's move on to the last case. Go back to Anna. Putin versus Purney. We are in the New Jersey Supreme Court. What's about to happen? Reverse the common law without fail. Go ahead. What were the facts there, please?
The Putin are the sellers and Purney are the buyers, and the Putin's going to sell their. They will enter into a contract to sell their $365,000 house, and the Purney put down $1,000, but there's no forfeiture or liquidated damages clause.
Okay, good. Keep going.
And then they back out.
Okay, good. Good. Yeah, you're good. You're good. Thank you. So what we have here is a real estate transaction using a standard form. I think I showed you last week, whatever the heck it was, the Texas Real Estate Commission form. This is a standard form. Everyone uses it. The buyer put down a deposit. Okay, so they put down a $36,000 deposit. Okay. There was a breach. As a result of the breach, there were some damages incurred. Okay. Jillian, were the damages incurred more or less than $36,000? The actual damages incurred, were they more or less than the $36,000 deposit?
They were more.
They were more?
I'm sorry, they were less.
Thank you. How much less? Good. Yeah. Yeah, yeah. So basically, yeah, $18,000 less. So keep it easy. The deposit was $36,000. The actual damages were $18,000. Okay. Jillian, under the common law rule, was the seller allowed to keep all of the deposit, or only the parts of the deposit that that reflected actual costs?
Only part.
No, under the common law rule. Sorry, not this decision. The common law rule.
They get all of it.
Yes, good. So exactly right. Under the common law rule, if the penalty was $36,000, if the deposit was $36,000, they could keep every penny of it. Even if their actual damages were $1, right? Let's say they sold it the next day and they made a full profit. They can keep the entire thing. Now, of course, this is a common law rule. We know that the New Jersey Supreme Court doesn't care for those. Avery, what does the court do here with this common law rule? Okay. Why is the court not willing to allow them to keep the full deposit instead of just the actual cost?
Because they say that, I guess, the Putin or almost have like unjust enrichment.
Yeah. Good. Give me remind your classmates. What's unjust enrichment?
Like the breach for that.
Yeah, because of this breach, they actually made out better than they would have otherwise. Why is that frowned upon in the law?
It's not really fair.
Why is it unfair?
Because of the breach, they made more money and they're going to make even more money.
Yeah, you're not supposed to profit off someone else's misconduct, right? That's the unjust enrichment doctrine. You're not supposed to profit off someone else's misconduct. So the court notes there's a growing recognition of injustice. I love when they use these phrases. A growing recognition of injustice concerning the forfeiture of deposits. And they cite contracts, and they cite Corbin. And the court used the retention of the deposit as like a penalty, right? That you're actually penalizing the buyer. Jesse, what's the problem with penalties in this case?
Well, they don't usually allow penalties in contractual arrangements, and they said that that wasn't fair and it wasn't just to penalize them, and they're entitled to the difference between the actual loss and the deposit.
Very good. So contracts has this sense that we do not allow penalties, right? And here, by allowing the seller to keep the full $36,000, you're penalizing the buyer. So the court says, look, we're moving away from this trend. This common law rule is unfair. Also, they raise this notion of efficient breach. Efficient breach. Caitlin, does that sound familiar? Did you study efficient breach in contract?
Yeah, it's when both of the parties are mutually benefited from
Good. Right. So the old notion, I say old, is that before the law and economics movement came out. I don't know if you heard, but Judge Posner, who was very influential, has stepped down this past weekend. He and I have had our differences, but I'll tell you about another time. But he stepped down. But one of the major contributions of Judge Posner is the idea of the efficient breach. Under the old understanding, a contract was a solemn oath. It was your blood promise, right? And to break a contract was to break your integrity and to break your ethics, right? Under the efficient breach approach, if it benefits both parties, why are you sticking around the contract? If both parties are better off through a breach, screw it, move on, sign a new contract, pay whatever damages you need, and then move on. So the New Jersey Supreme Court's new holding is premised on we want to allow efficient breaches. Because in this case, if the buyer wants out, let him get out and you pay the $18,000 and everyone's basically where they were before. But don't give them the full $36,000 because that dissuades, that disencourages efficient breach. Okay? This is an exercise of unjust enrichment. One other question. Paige, what is a liquidated damages clause? Does that sound familiar? Liquidated damages? Exactly. Yeah, it always sounds like, water. There's nothing with water, right? You have enough water. Liquidated damages refers to stipulating in advance, if there's a breach, here's how the damages will be allocated. And very often they'll say, if you breach, we retain the entire deposit. Paige, did this contract have a liquidated damages clause? If it had a liquidated damages clause, how would the case have shaked out? Let's say the liquidated damage clause says we retain the full deposit no matter what. You'll never get it back in the event of a breach. I can't, you're a little bit louder. Do the courts always enforce liquidated damages provisions? Are they always going to be enforced? No, why not? In what case will they not be enforced? You can take a guess, you'll probably be right. Travis? What makes it unjust enrichment? Why would a liquidated damage clause not be enforced? What's that word? That four-letter word. Fair, or reasonable, right? Good. Courts will not enforce a liquidated damages provision if it's unreasonable. And what makes it unreasonable? Fair, unjust enrichment, whatever. You can tell my sympathies for this doctrine when I say whatever, but that's basically the answer, right? If it makes a judge feel icky, it's probably bad. Whatever. I don't know much about it. I like common law rules because they're certain, they're not very fair. The modern rules are not certain, and they are whatever, right? They're fair. So here the court orders the restitution of, $18,000, whatever the difference was in the deposit. And again, they changed the common law rule. So, Travis, I'll stick with you for a minute. if you were a lawyer doing real estate law in New Jersey after this decision, what are you going to be doing to all of your standard real estate contracts? Yes, exactly, perfect. The standard form didn't have a liquidated damage provision because it wasn't needed, right? Under New Jersey law, it was understood that the seller could retain the full deposit. But now, with this new decision, you got to modify all of your contracts and make sure that you specify that in the event of a buyer breach, the damages are liquidated. The deposit will be retained and not recovered at all. Oh, yes, sir, Adam. Oh, yes, ma'am, sorry.
Doesn't it make it sound like if you did include like a legal
They sure did. They sure did. Anyone else notice at the very end? Yes, they basically hint this is what I was trying to get at with Travis. Even though you put a liquidated damage provision in, there's no guarantee it gets enforced. This is a really significant change in property law, right? Before this, Anna, you're a lawyer for a real estate developer. You say, look, under no circumstance do you ever have to give back the penalty, so don't worry about it. Don't even put this provision in, just whatever, right? But now, you can say, look, if this thing breaches, you keep your expenses low because you're going to have to pay back the difference. So this decision makes a significant change in how damages and what do you call them? Penalties recovered. All right. So I'm sorry? All right, I heard it. So the whole thing then of this case is at once, small but at once big. It basically says the general rule, right? The general rule is that you cannot keep the deposit beyond your own expenses. You have to give back any additional profits you make from the deposit. And if you have a liquidated damages clause, you're probably in the exact same boat anyway. So you can't contract around it. I can't see your name. Is that Christina? Mm-hmm. So Christina, then you're now a real estate developer in New Jersey, right? And you know that you're probably going to get screwed if the buyer breaches. How do you modify your land transaction to deal with this new reality? What might you do? In other words, this decision makes it easier for the plaintiffs to breach, right? It makes it easier for the buyers to breach. What might you do, Christina, to help out your developer friends if you're their lawyer? Yes, exactly what I'm thinking of, exactly. You make deposits higher, right? You make the cost of the breaching more, right? Instead of 10%, requires 20%. That makes it that if you're not serious about it, you won't put the money down, right? The more money someone puts down, the more likely they're serious about it. So you might, wait a second, Jesse. So you might deal with this decision by jacking up the deposit rates. Jesse?
If they know the law, does jacking up the deposit rates matter at all?
Nope.
Who cares if you know you can break it to get a better deal?
Nope, and that's why it doesn't matter. You're going to be screwed anyway. The only purpose is you're screening out buyers, right? You're screening out people who are more or less serious about it.
What about application fees? Isn't that a way at least get some of it?
Yeah, you make a $30,000 application fee.
Like $50.
No, I mean, your question is a good one, right? Your question is a very good one. You can get actual costs reimbursed, so if you make a very high application fee, you get that back. So the deposit's $5,000, the application fee is $25,000, right? I think the court would probably find that unreasonable, sure. But I mean, you've had this, like where you apply for apartments, and every time you apply, it's like a $75 fee. You're never getting that back, right? That's gone. Mia?
Oh, I don't have a question.
I saw a hand. So any questions on this case? All right, so let me synthesize a bit and I'll let you guys out a tad early and go home and get some rest. The doctrines in this case, I'm sorry? It can be nice. You can nap somewhere, try to help out. I don't know. The doctrines in these cases represent the chipping away of the common law. You're sensing a trend. And invariably, every case, it's making it more pro a buyer, right? In the first case, the Lemke case, the court eliminated the requirement of privity between a subsequent buyer and a contractor when it comes to latent defects. And so long as those latent defects are reported in a reasonable time, the subsequent purchaser can go after the contractor directly. The second case, the Jones v. Lee case, actually allowed for the recovery of the difference in purchase price, right? That if a buyer backs out and the seller ends up selling for less, they can get damages based on the difference in purchase price, although they didn't agree with the purchase price and market price was. And the final case, the one from Cutson, says that the down payment, the earnest money, the deposit, is not a penalty, and you can only keep whatever costs you incur, and the rest goes back to the buyer. Yes?
Can you say the last one again, so the third case?
Yeah, so the last case, the New Jersey case, was that the down payment, the earnest money, is not a penalty. And if there's a breach, the seller can only keep what his actual damages are. And anything above that has to be refunded. It's called restitution to the buyer. Anything else? Yusuf.
Well, for the second case, the loss of the margin rule, how we learned it in contracts was that you can either use the market value or the resale price. For property, is it that they always need to find the market value of the property?
Yes. So the court would have to make a one-sentence finding. I find that the market price was the resale price. Done. Had the judge said that one sentence, the case would have been different. Yeah. Anything else? If you have any knowledge of any classmates that are in need, you can tell me after class. We want to find who they are. Otherwise, I will see you all on Thursday. Thank you so much.